Okay, welcome back to the Senate Committee on Judiciary. I want to thank everybody for their patience and thank everybody who came to join us this morning for our testimony on Assembly Bill 291. I would note that we do have available in the committee room and also here for the committee members a mock-up of Assembly Bill 291. We allowed for some time for folks to kind of digest some of the things that we talked about in the hearing. I would note that the committee members should have a full mock-up and also a work session document in front of them, and so we are going to have a work session on this bill. Obviously, as we move towards the end of session, things need to move a little quickly because we are running out of time to continue to hear bills and schedule work sessions, and so I would anticipate that for the next 5 days, we will continue to have work sessions and bill hearings in a very quick manner so that we can accomplish all of the things we need to accomplish before we leave this legislative session. With that, I'm going to go ahead and turn the work session over to Mr. Guinan, who can just walk us briefly through our work session documents and the mock-up.
Thanks, Madam Chair. I'll be very brief. This is Patrick Guinan. For the record, we just heard the bill and the proposed amendment this morning. So just very, very quickly, this is Assemblywoman Howdigee's bill. It was heard in this committee on April 1st and May 29th. This is AB291 in its first reprint. The members have a summary of the bill in its R1 form on the bill page, and then following that summary is a rundown of the amendments as they were proposed today. And I would just note that the rundown of the amendments as they were proposed today is essentially taken directly from the digest of the bill. So there's nothing different in this except for the very last entry on the bill page, which is highlighted in yellow for the committee, and I guess it would be highlighted in gray in the public copies. But that's the notation, just that section 26 of the mock-up has been revised to reflect changes that were requested by John Jones on behalf of the Nevada District Attorneys Association this morning. That change removes language requiring that the negligent storage of a firearm must have caused injury to a child or another person in section 26. Otherwise, this is exactly the same amendment that was discussed at length this morning in committee, and so the motion would be amend and do pass, Madam Chair, and that's all I have.
Thank you, Mr. Guinan. Are there any questions from the committee members regarding the work session document? Senator Pickard.
Thank you, Madam Chair. Do I understand then the amendment, the new amendment to Section 26, does not require any harm to occur to anyone before it's considered a violation?
Thank you, Senator Pickard. Yes, and if you recall from the testimony earlier today, I think the concern is that with that language in the bill as is, it would prohibit a situation wherein you would be able to charge child abuse if somebody is actually injured. Certainly, it wouldn't necessarily preclude if there was an issue with the negligent storage of the firearm in the first place, but that language would cause an issue with current ability to charge for child abuse, and I think that that's what Mr. Jones testified to.
Okay, and I guess that's at the core of my concern, because if there's no abuse that has occurred, then it's not child abuse, unless we want to create a new species of abuse. And this would be insufficient to do that. As I understand, under 432B, there has to be actual abuse or actual neglect that's proven, and this is inconsistent with that.
And Senator Pickard, you're referring to Chapter 432B, which deals with issues of child welfare and the safety and well-being of a child. When we're talking about child abuse, we're talking about Chapter 20, I believe it's 205, which would relate to felony child abuse, which is criminal in nature, not civil in nature. And so that's where the conflict with this particular section of the bill comes, in that it would essentially prohibit the charge for felony child abuse if somebody were to place a child in a situation where they suffered unjustifiable physical harm. And so obviously I think it would be more prudent and policy forward to say that if somebody is in a situation like that where a child is injured, that would be felonious and not misdemeanant conduct.
Okay, maybe I don't understand, because I thought that this removes the element of actual abuse to occur. So if there's been no harm to the child, how does that then create a felony?
So in the event that somebody were to be harmed with a firearm, that would be actual physical harm to a child. And so that would be a felonious conduct. Under this bill, if you have the language in there that says, and it causes harm, then potentially it could be just a misdemeanor, which I don't think is the intent. I think the intent is to say that there should be some provisions for the negligent storage of firearms, but in the instance where actions are causing for a child to be actually injured, that falls within the realm of child abuse.
All right, so this goes back then to my original question. So we are charging someone with a crime without any actual conduct having occurred. Is that correct?
Thank you, Senator. No, that's incorrect. There would be conduct that had occurred, which would be the negligent storage of the firearm. Vice Chair Harris.
Thank you, Madam Chair. Just for some clarification, in a situation where a child is harmed, but it is not your child, and that harm is caused by the negligent storage of a firearm, under that scenario, would you still only be able to be charged with the misdemeanor?
Thank you, Senator, for the question. And I would point out two things. First, the provisions that are included in this particular bill also require an intent or knowledge element with. And I think intent is probably not the right word, but a knowledge element with respect to knowing that the firearm should be stored a particular way and then the inaction to do so. So potentially it would fall under this. Given the certain facts and circumstances surrounding that particular scenario, I think there's a potential that it could also fall within the realm of child abuse. But that would depend on particularized facts of that situation. Additional comments or questions on the work session document? Okay. Seeing none, I would take a motion to amend and do pass.
So moved.
So moved by Senator Scheibel, second by Vice Chair Harris. Any discussion on the motion? Senator Orenshall.
Madam Chair, I appreciate all your hard work on this bill, and Assemblywoman Howdigee, I still have some questions about the high-risk protection order, and I appreciate the section in there that tries to prevent abuse, let's say in a divorce action or child custody action, but I still have some questions. I think this is an important enough issue that it should go to the floor. I'm going to vote to support it and reserve my right.
Senator Hansen.
Thank you, Madam Chair. Just want to, I was disturbed this morning in testimony when the ACLU mentioned they'd had the amendment for 24 hours and we didn't see it till 7 a.m. this morning. So I think this has been an abusive process. I think it's one of the reasons that the people in general have very low opinion of the legislature and the legislative process when these sorts of things go through. I think that the fact that we're voting on it when we literally just got this very substantial amendment on a bill that we all know has been exceptionally controversial, to just ramrod this through, I just think is a horrible abuse and a mistake. And so I object to the process, and I'm definitely going to be voting no.
Thank you, Senator. And I would again remind the committee that the provisions that are included in this bill were not only included in a bill from last session, which was also heard in the Senate Judiciary Committee, passed out of the Senate floor, also was heard by the Assembly Judiciary Committee, of which members of this body also served through a very lengthy hearing, was worked on through the interim, was part of a Senate bill this particular session as well, that has been, the language has been out there for quite some time. And then the other portions of this bill, obviously we heard in a joint session and have been sitting in this committee. So just wanted to make that point for the record as well.
Well, Madam Chair, if I could respond, the reality is that the public was not aware of it until this morning, and the public did not get an opportunity to participate in all the things that you just mentioned. So it just looks bad. It just looks really bad. So and some of those bills we didn't sit on those things, and several of them we thought died on the deadline. So the idea that we're all prepared and we've been discussing all these specific issues is simply inaccurate. So I just think I want to get that on the record.
Any further discussion on the motion? Senator Harris.
Thank you, Madam Chair. I'd just like to let the record reflect that I've been lobbied heavily on every provision in this bill, both from those within this body and outside the body, including the provisions that had not been previously heard. So some people got the word out, and they made sure they tried to get the word back to me. So I very well aware, I've had full discussions both with the public and people inside this building.
Senator Pickard.
Thank you, Madam Chair. I appreciate the hard work that's gone into this. There has been a lot of conversation that's gone on. Unfortunately, we've been left out of that. And I appreciate the fact that my colleague has been brought up to speed. But again, we weren't. And I think it's really problematic to suggest that language that's been hanging out in the open in the past would even be considered in the context of this bill until it's actually included in this bill. The language that we discussed last session did not make it out for many of the same reasons that this one was discussed. But the fact of the matter is, we don't read language in the context of a bill until it's included in the bill. So to suggest that just because someone had the language out there and maybe a couple of us have seen it in the past, I think that's disingenuous. I think that if we're talking about the bill, we've got to talk about the bill as it is presented to us, and we had an hour before the hearing to read it. I just think that that's completely inappropriate. Outside of that, I agree that the provision that makes it a crime to falsely file an affidavit is probably the best part of this. In my experience, I see TPOs abused on a regular basis, and there is no provision for a penalty for doing so. It becomes a tactical advantage in their particular case. This probably won't suffer the same kind of circumstance, but that doesn't speak to the constitutional issues that we have here, particularly now that we're including with no real notice a provision that creates a misdemeanor when no actual conduct can be proven. So I think that because this bill has not been thoroughly vetted, because it was dropped, this amendment was dropped at the last possible moment, we've done a great disservice to this state. We're going to put people in jeopardy. We're not addressing the central issue, which is the mental health issue. We're not addressing the constitutional problems, and this is just yet another example of how we are ignoring our Constitution. So I'm going to be a definite no on this, even though I would like to see us address in real terms how we deal with these situations. This is not the answer.
Senator John Darrell Loop.
Thank you very much. My comments would go to all of my colleagues. We have a varying amount of experience on this panel. And I think that I'm not sure who we is, because we are the Judiciary Committee and we are all sitting here together. I would only say that this is my fourth session, and I have never been through a session where there haven't been amendments that have come forward on any type of a bill in the last final days. Bills have been dropped, bills have been amended, bills have been killed, bills that you thought were going to go through didn't, and vice versa. This is a very short process, and so when you have 120 days and things get fast and furious, I think that we have to make the best use of our time that we can. And our legal counsel, our research people, and everybody, all the staff involved, as well as legislators, I think I can't imagine any of us are being disingenuous. I can't believe that any of us are less than professional. I've sat between my colleague to the right and to the left, who are very different degrees of experience, but also have the same degree in life. And I've learned from both of them, and I don't think that either one of them have ever been disingenuous to me. And so for me, I think that we have to move forward quickly. And we have heard this bill, I believe this is the third time now that we've discussed it. I could be wrong. I think we discussed it at the beginning of session, and I think we had another hearing here in this body. And then we had maybe even a discussion this morning, and now we're having work session. So while I recognize we have to read fast, I did not have this any sooner than any of the rest of you had it. And I would like to go onto the record saying that I got this exactly when you received it. I was sitting next to you when I received it. Thank you.
Further comments from members of the committee at this point in time regarding the work session document or the mock-up? The one thing I just did want to note is that there is a difference certainly between conduct and injury. Conduct doesn't always constitute injury, and I think that's what this bill is intending to get at. And so I think with respect to the provisions that would penalize conduct that doesn't cause injury, it certainly is meant to get at actual conduct. So we're not just penalizing individuals for having done nothing. The other thing I would note is that many of the things that we heard in this bill today also mirror domestic violence statutes for the provisions and allowing for the provisions of removal of firearms from individuals who are prohibited possessors of firearms. And I think that that's an important thing to note just for the record. The other thing about this particular concept of red flags laws is that it did actually also get discussed as part of a 2018 Attorney General Adam Laxalt chaired committee on school safety that would have recommended for red flag laws to allow for the temporary confiscation of firearms. And so this is not a new concept for individuals, certainly in this body, in terms of discussions. And so I feel comfortable with the language in that it provides a sufficient due process periods for the review of those particular protective orders, and that it also is serving a need to ensure that individuals who shouldn't have firearms because they pose a danger to themselves or others do not have firearms. With that, we have a motion to amend and do pass. All those in favor, please signify by saying aye. Aye. Any opposed? No. Madam Secretary, motion carries. Nays are Hammond, Hansen, and Pickard. With that, we are done for today's work session. We do have some items on the agenda. I would note that we will be hearing bills tomorrow, and we would expect to be getting some bills, of course, from the Assembly as well. So just keep an eye on those agendas because they will get posted as we start to receive those items and start scheduling them. We will see everyone back here tomorrow at 8 a.m. We're adjourned.